Okay, so up next, we're going to talk about something that sounds very serious, which is the National Security Act. Really, we as per videos on Geeksvana, my viewers will be aware that the National Security Act is now in force. But really, we need to know, as drone pilots, what the status is of prohibited places under the NSA. At the moment, drone pilots are obviously not openly notified as of no-fly zones related to this. But really what I want to know is, can police take action against a pilot under the National Security Act at the moment for any of the issues surrounding the National Security Act? Or, and how would they find out? I know eventually it's going to end up on things like Drone Assist, etc. It'll end up on the AIP. But where do we stand?
Yeah, no problem. Thanks for that. So I think it's worth saying, and this is a point I meant to make it previously. This legislation, a lot of drone legislation, are things that impact on drone use across the UK. It is new for everybody. It's new for the regulator, it's new for the public, it's new for industry, and it's new for police as well. So we are, to an extent, all finding our feet in this. It will take time. I think, as we get more clarity, things will become more straightforward. But for the time being, as I say, this is new for a lot of people. So the implications for the National Security Act in relation to drone use, they are quite chunky, they are quite sizable. There's nothing in the National Security Act that specifically deals with drones, but drones do feature in part one, which is really, as you say, around the prohibited place thing. So interesting elements to note there. As you say, in time, I think these will start appearing on the ENR 5.1, which is the one place I go to, the single version of the truth. I think the CA are going to be publishing them under Article 239. So it won't just be a prohibited place, it will actually be a 239 restricted or prohibited area as well. That will provide clarity, because obviously that's a framework that people understand. The elements are that for a prohibited place, or for a site to be designated a prohibited place, they've got to either access one of the mechanisms in Section 7, and there are 3 that they can do. One relates to MI5, MI6, and GCHQ. One relates to Crown land being used for a variety of purposes, and another relates to non-Crown land, so effectively private industry and a variety of others, where certain activities are taking place on that site. If a site thinks they should be designated a prohibited place and they don't automatically qualify under Section 7, they can apply to a Secretary of State under Section 8, set out their case. The Secretary of State will then make a decision, and that prohibited place will be effectively confirmed to be one and published on a variety of places. Now, I think it is worth noting that at the moment, there is no legal requirement for sites to be notified to the public in a particular format. I think you will start seeing a lot of signs going up, and you will start seeing sites appearing on things like the ENR 5.1 maps and that kind of thing. But that's not something that is a necessity. So it could be that there's another way that information is communicated to somebody who's being dealt with, and they could still engage those acts there. Interesting ones to note are Section 4, which is around putting a device over, or there's a variety of things, and again, it's worth looking at the actual wording of the legislation. One of the things that applies there that is of interest is that if somebody is in the vicinity of or approaching a prohibited place with a device, and that's really, I guess, what we're talking about here, they could engage that Section 4 offence if they're doing it for a purpose they know is prejudicial to the safety or interests of the UK. And that safety or interest to the UK, that really is what the whole act is about. It's not just about sabotage, it's not just about espionage, it's about a variety of other things, but it all comes down to that safety or interest of the UK piece. One of the things it says in Section 4 and Section 5 is that it's not only an offence to effectively place a drone over a prohibited place, it's also an offence to inspect a prohibited place with some form of device. So that could mean that the drone is flying outside the wire, if you like, outside the compound. But if it's inspecting that site, that could be enough to engage the offence. It doesn't even say they have to be recording. Merely inspecting it, viewing it through the camera could be enough. So I mentioned Section 4 is about doing it for a purpose prejudicial, that the person knows is for a purpose prejudicial to the safety or interest of the UK. The Section 5 offence is, if you like, it's the little brother of that one, and that is doing it where the person knew or reasonably ought to have known that doing so was unauthorised. And it's those two things really that that point to the requirement for some form of information to go out to the public, so the pilot has got a chance of knowing whether they're committing this offence or not. So as I say, for Section 4, they have to know or reasonably ought to have known that doing so was for a purpose prejudicial to the safety or interests of the UK. And then for Section 5, they have to know or reasonably ought to know that it's not authorised. So it could be through a sign, it could be through a map, or it could be through information that's passed to them from a member of the security team or a police officer who's called or anything else.
Yes.
There is a power under there, Section 6, I don't know if you want to put it up at some point.
Will do.
But there is a power for police effectively to move people along. So if somebody is at a prohibited place or they're inspecting a prohibited place from outside, then the officer can require them to leave, basically. Now, in that sense, it's going to be very difficult for a person to argue that they weren't aware, and that's where the Section 5 thing would apply. As I say, a lot of this is new. A lot of it is still being developed by government departments, and police are recipients of that in very much the same way as the public are. But I think in time we will get that clarity.
Absolutely. So there are a couple of things that I take from that. And firstly, that actually, even when these no-fly zones essentially are populated onto things like drone assist and on the ANR, there will still be other sites that are not on there that are prohibited places. So it could be that the first time you find out about it being a prohibited place is a member of security coming up to you and informing you. And I think that's important to stress because, of course, once this does appear on the various maps, what I don't want to happen is my view is to say, hang on a minute, it doesn't show on drone assist, it can't be a prohibited place. But
sure.
I would hope people at home would understand why some prohibited places aren't marked on public maps.
Yeah, that's exactly it. And some of them we know from conversations, some of them don't want to put signs up, they don't want to appear in any maps, they don't want to draw attention. And it might be that, you know, there's another way that site has to deal with it. Some of these sites, by the way, are in existing FRZs, for instance, or existing areas where 239 applies. So in that sense, they enjoy the protection of drones not being able to fly without permission. So actually, they get what they need without having to tell the world that site is involved in something which is linked to the security and interest, safety and interests of the UK. What I would say as well is that ultimately, a lot of these things are going to be for a court to decide. So it might be that a case is presented to a jury or to a magistrate or to a judge that says, okay, this is the information saying that the pilot knew, or they should have known, and then it will be for the person to explain why that wasn't the case, or why it's not fair to make that presumption. But in time, as with a lot of drone legislation, we are waiting for the courts to build up a body of cases, a body of examples to provide that clarity that we're all seeking. And as I say, we're certainly all in the same boat about wanting that clarity to come down the line.
Indeed, exactly. And I don't want people to fear flying their drone because of this kind of thing. You know, it is, especially at the moment, without, you know, obviously I would say, if you go and fly your drone over MI5 or GCHQ or you know, somewhere of that type, then, you know, you should expect a bit of trouble, basically, frankly. But of course, you know, these things are in place for what the government have deemed good reason, and obviously security services have deemed good reason. And at the moment, the first time you're going to find out about it is basically a tap on the shoulder to say, hey, by the way, you are flying, you can't fly anywhere here, it's a prohibited place, please don't film it, etc., etc. And I think it's just important for people to know that, because that won't always necessarily be a uniformed police officer that's coming up to you. It will be somebody that identifies themselves with the credentials of the security of that facility. And again, we're not just talking about grey office buildings in the centre of London. You know, we could be talking about a manufacturer that on the outside says we make trainers, but actually they could also make a component that goes in something else that is essential, and therefore they could be a prohibited place and a protected place because of that. So the list of reasons, and as you were stating, it's a Secretary of State. There isn't one particular Secretary of State that can put this. So different industry can approach their own Secretary of State to get that prohibition, and it's down to that Secretary of State to deem it correct. So I think there's going to be some, perhaps not necessarily straightforward reasons why some sites are going to be on there. So be aware of it. Don't be surprised. Now, you also mentioned Article 239 is probably how the CAA are going to deal with it. So it is worth stating that once these things come on, they're not going to be danger areas or areas of interest. These are going to be little red, I was saying circles, but they're probably going to be, I would assume there'll be squares around the actual.
I think it'll depend on each site, but ultimately this is about giving people the opportunity to avoid getting themselves into trouble.
Yes.
And it might be that if somebody is flying in an area and they aren't aware that they're inspecting a prohibited place, they're viewing it from outside the wire, it's going to be difficult for them to argue that they weren't aware if they come back and do it again. So it might be that in the first case, effectively they get a warning and that's the end of it. But if they come back again, then it's going to be difficult for them to argue that they weren't aware.
Indeed, and of course the as we're now putting up on screen right now, I'll have our editor do that. You can see that the punishment in terms of the two sections is also very different. One is obviously perhaps what you would expect, and the other one is of course in terms of that person really has been caught doing something very nefarious and can expect to find themselves in prison.
It's worth saying as well that the Section 4 offence requires a very high level of authority to prosecute, to charge, at Attorney General level, which is incredibly high. So I don't think we'll necessarily see many Section 4 prosecutions, but if the evidence is there that somebody was doing it deliberately for a purpose prejudicial, and that might just be shutting down activity at the sites, if they do it with the intention of activity on that site being disrupted or deterred, then actually that might be enough. But because the level is so high, I think Section 5 is the one that I think we're probably more likely to see.
Okay, excellent. It's a really important subject. I'm sure we'll have some other questions over time on it. As you say, everybody's getting used to it, so please do bear that in mind. Don't expect the security or the police to know everything verbatim on these sites and the legislation behind it. And as you say, this is something that needs to be tested, and the limits need to be set by the courts as we go through. So
I don't think anybody wants to be the person to test it.
No, thank you.
At some point, somebody's going to find themselves on the wrong end, and it's not going to be good.
Yes, but again, obviously at that point in the situations we've been explaining, it would have to be somebody that has refused to leave at the moment. So obviously either you are flying in a zone that the maps are telling you shouldn't be flying in, or you're flying in a zone that somebody has asked you to leave for that reason.
Actually, that warning isn't required.
Okay.
The Section 6 offence would apply if the person was told to leave and then didn't. But actually, just doing it in the first case, if that information is out there, that might be enough to look at a Section 4 or a Section 5 charge. Yeah.
But the only thing you'd have to prove, obviously, is the pilot reasonably knew that he shouldn't be flying there,
or reasonably to have known.
Yes.
That's right, and that's why a lot of sites are going for the signs. They are going for the maps, because if that information is there, then it could be that they have to explain to the court why it's not reasonable that they should have known. But as I say, we don't really want anybody to be in that position.
No, of course. No, indeed, exactly. So for instance, okay, as a police officer, let me give you a scenario. If you were approaching me flying my drone, and I was a couple of streets away from a prohibited building, and I haven't actually been along that street, and it's not showing on the maps, and I fly my drone, and obviously I'm flying towards the prohibited place, which is enough to raise alarm. Presumably in that kind of situation, would you as an officer say that you would not expect me to have reasonably known, because of course I haven't walked all the streets that I'm necessarily flying over?
So I think it would depend. I think there's a conversation to be had about checking things like the maps. There is information going to be out there, and that's one of the reasons that this is being pushed by government, so that level of awareness is there. it might be that actually on that first interaction, it might be that that is the gift of information given to the person to avoid them committing that offence. Or it might be that if they have checked the maps, or they've said they've checked the maps, then actually they should know. But again, I think it is worth saying, Sean, that I think one of the things that may be a surprise to people is that even looking at a prohibited place may be enough to engage those offences. So even inspecting it through a camera from a couple of streets away might be enough to engage those offences. And that comes back to a point we've previously talked about, making that requirement for the drone to land.
Okay, yes. So you may all find the things connecting there. And yeah, no, indeed. Excellent. Thank you. Okay, and a follow-up question regarding prohibited places, and this is one which has come via email from another viewer, and they're sort of approaching this from the angle of a content creator. Essentially, it's not me, by the way, and it reads: if a YouTuber is filming GCHQ, for example, which is definitely a prohibited place, but they have no ill intent, would the below section of the Act mean that no offence is committed? And I'm going to put on screen the section they mean here and just read it quickly. That conduct is for a purpose that the person knows, or having regard to other matters known to them, ought reasonably to know is prejudicial to the safety or interests of the United Kingdom.
Yeah, no problem. So firstly, to mention that the main GCHQ building, you'll be aware, is in an aerodrome FRZ. So
of course,
shouldn't be flying that close to it anyway. But no, a point taken on the prohibited place thing, and obviously there are other GCHQ sites across the UK. So that's very much focusing on the Section 4 offence rather than the Section 5 offence. So even if the person can't evidence or provides the representation there and then that they don't have any ill intent, actually they may find that that is still something they have to explain to a court later on. As I say, the prosecution threshold for Section 4 is very high. But when you look at the Section 5 offence, if they knew or reasonably ought to have known that they weren't allowed to inspect that prohibited place with a device under the legislation, then actually that Section 5 offence would still be in play. Yeah, absolutely.
So yeah, it is worth emphasising that with Section 5, the intent isn't really something which you have to prove. It's only on the Section 4 that's as you say, there is a very high bar for that one. But Section 5,
yes. Section 5 is that it was unauthorised,
yeah,
and the person knew or ought to have known it was unauthorised, and then there's a bit around whether that person was in a position to be able to provide that authority or not. But again, it's all in there. Section 5, it's well worth a read.
Excellent. Thank you very much.